Welcome back to the Constitutional Clarion. This video is the last, finally, in this series about the New South Wales Lang Government and its dismissal. I hope you found the rest of them interesting. To me, it illuminates a lot of interesting constitutional issues, including the exercise of a reserve power. This video is about the debate over whether Sir Philip Game was constitutionally justified in his exercise of the reserve power of dismissal. Some have argued that Lang's dismissal was a consequence of disagreement on policy issues or the result of conservative pressures in Sydney and London. The Governor's words and actions, however, make it very clear that the ground of illegality was crucial to the dismissal. No doubt the political and economic crises within the state were a contributing factor. No governor would dismiss a government for a simple breach of the law. If they did, we would have lost quite a lot of governments by now. It was the relationship between the breach of the law and the inability of ministers, quote, to carry on essential services without breaking the law that caused the governor to act. But without the factor of illegality, it appears that the governor was not prepared to intervene. He had already resisted for a long time the strident calls for him to dismiss Lang because he felt he had no constitutional ground upon which to do so. Sir Philip later explained in his private correspondence with the King, quote, "Whether I acted rightly or wrongly in the final resort, I cannot say, but I feel that I was right in resisting the very strong pressure to take action at any earlier date. I had no basis for doing so except for reasons of policy, and I felt and still feel that it would have been a fatal mistake to have forced the issue on such a basis. A clear-cut issue of legality seemed to me an entirely different matter," unquote. Not all governors are legally trained. Game was not. One consequence is that if a governor feels uncertain about the legality of acts that he or she is being asked to authorise, the governor is entitled to delay acting until he or she receives advice from the Crown law officers, these being senior government lawyers. They could be the Attorney General or the Solicitor General or some other very senior government lawyer. If the governor receives legal advice that the action is lawful, all responsibility for that action passes from the governor to his or her responsible advisors. Game followed that orthodox approach in November 1930 over the repeal of referendum requirements and in April 1932 in relation to alleged breaches of the Audit Act. In both cases, the governor accepted the advice of the Crown law officers that the acts were lawful and he didn't intervene. The difficulty for the governor in May 1932 was that although he asked for advice as to legality, it was denied to him. He no doubt formed a reasonable suspicion that this was so because the Crown law officers were not prepared to put their names to a legal opinion asserting that the state circular was not instructing public servants to breach a Commonwealth law. The governor's difficulties were exacerbated by the fact that Lang did not even attempt to assert that the actions of his government were legal. Sir Philip Game, in one of his letters to Lang on the 13th of May, said, quote, "I gather from your letter that you do not dispute my view that the circular in question is a breach of federal law," unquote. In a later letter to Lang on the same day, he referred to their meeting and stated, quote, "The position as I see it is that ministers are committing a breach of the law. While you did not admit this, you did not deny it," unquote. Without the comfort of an opinion of the Crown law officers, the only other authoritative source upon legality was the courts. Sir Philip Game is primarily criticised for usurping the role of the courts in making a determination of illegality. This point was made by Mr. Justice Piddington when he resigned his judicial office in protest at Lang's dismissal. He argued that the governor's action was unconstitutional as the governor was acting as a tribunal exercising federal jurisdiction to hear and determine federal offences contrary to Chapter 3 of the Commonwealth Constitution. The High Court, however, had already upheld the validity of the Commonwealth's Financial Agreements Enforcement Act, and in a second challenge, it had upheld the power of the Commonwealth Parliament to seize state funds from the banks. The act of dismissal needs to be viewed in the context of all those events leading up to it. Sir Edward Mitchell made that point when he argued, quote, "I would agree with Mr. Justice Piddington that, if the circular stood alone and were not the culmination of a series of attempts to obstruct and disobey the laws so declared valid, it would not be proper for His Excellency, on his own responsibility, to determine whether federal regulations were valid or not," unquote. Sir Edward, however, looked to the entire history of attempts to, quote, "disregard and disobey federal laws which the High Court had determined to be valid and binding on the state of New South Wales in actions to which the state was a party," unquote. It is likely that Sir Philip Game, as a non-lawyer, regarded the High Court as having already determined the issue of legality after the series of judgments it issued in April and May, upholding the validity of the Commonwealth's laws. Was it necessary for manifest breaches of those laws to be litigated, especially when the Premier had not denied that a breach of the law had occurred or taken any steps to assert that the government was acting legally? In this case, the direct clash was between the state circular and the Commonwealth regulations and proclamations made under the Financial Agreements Enforcement Act. While the validity of that act had been upheld, the validity of regulations and proclamations made under it had not yet been considered by a court. H.V. Evatt rightly argued, quote, "In the first place, neither the validity of the Commonwealth Proclamation nor its application was ever determined by a competent legal tribunal. Secondly, there were competent courts with jurisdiction to determine such questions. Thirdly, if the question had been determined adversely to Mr. Lang, injunctions could have been issued preventing both him and all others concerned from acting upon the circular objected to," unquote. While that may be true, it's also the case that no one seriously suggests that the Commonwealth regulations and proclamations were invalid, or that the state circular was not instructing public servants to act contrary to the valid law. The issue here is simply one then of time. And time, in the politically fraught circumstances of that period, as I've tried to show in the previous videos, could have led to danger and violence. As a general principle, if the issue is justiciable, that is, something that can be determined by a court, illegality should be determined by a court rather than the governor before it can be used as a ground for dismissing ministers. However, one problem with this view is that it potentially leads to an infinite regress of litigation if the governor is not permitted ultimately to exercise judgment himself or herself as to cases of what Sir Isaac Isaacs referred to as plain illegality. Isaacs himself had also written to the King explaining that Game had acted correctly. He considered that once Lang had acted in open breach of Commonwealth law, which is made binding on every state by covering Clause 5 of the Commonwealth Constitution, the governor was entitled to act. He saw Game as applying a recognised constitutional remedy to put an end to an attempt to govern both illegally and unconstitutionally. If it were accepted that illegality was occurring, the question remained as to whether the governor should have exercised his reserve power to dismiss the Premier. Not all cases of illegality would justify such serious action. An advisory committee to the Constitutional Commission suggested in 1987 the government would have to be, quote, "persisting in grossly unlawful or illegal conduct, including a serious breach of the Constitution," unquote, before dismissal would be justified. It has long been accepted that both the governor and the government are obliged to obey the law. This is a fundamental requirement of the principle of the rule of law. As the British Secretary of State advised the New South Wales Governor in 1870, quote, if the law required him to do one thing and his ministers recommended him another course, it was his plain duty to obey the law, unquote. However, declining the advice of ministers to perform an unlawful act is not of the same magnitude as dismissing a government. Further, this was not a case of the governor being asked to participate in an unlawful act. Lang had been very careful to ensure that his directions were issued by public servants and were not submitted to the Executive Council. Sir Philip was concerned, nonetheless, that it was the Crown that was involved in illegality because the circular had been issued by the government and was instructing public servants to act in breach of the law. He saw the authority of the Crown as being derived from the King through himself as the King's representative, and stated in a letter to Lang on the 12th of May that, quote, I cannot possibly allow the Crown to be placed in the position of breaking the law of the land, unquote. In effect, he saw himself as responsible for guarding the integrity of the Crown and the Constitution. This view was not unprecedented. The New South Wales Official Yearbook of 1931 described the Governor's role in the following terms, quote, the general nature of his position is such that he is guardian of the Constitution and bound to see that the great powers with which he is entrusted are not used otherwise than in the public interest. In extreme cases, his discretion constitutes a safeguard against malpractice, unquote. It did not, however, mean that the governor could be some kind of constitutional vigilante seeking out breaches and meting out punishment. As the yearbook stated, the governor's powers could only be used in the public interest and in extreme cases. Did the governor face an extreme case in May 1932? Certainly the circumstances were extreme and they remain unprecedented. Should he have held his hand and waited for a further court finding? It's easy to say from a distance that he should have waited and left it to the courts to resolve. But the weight of responsibility on the governor in the circumstances of the day made it a much harder decision for him to make than it is for us to make in retrospect. There was a very real risk of violence and revolution if he had waited even as much as a day. It wasn't just the New Guard, there were also other forces, including secessionist forces, who were organising and marshalling weapons for a rebellion. Personally, I don't think anyone is entitled to condemn Game's decision unless they have stood in his shoes and faced the dilemmas that he faced. People think that the role of a vice-regal representative is all canapes and champagne, but there are times when it involves making truly hard decisions with huge ramifications. And that's why we need to choose people with gravitas, wisdom, and common sense for those roles. Thank you once again for watching the Constitutional Clarion, and as always, I look forward to seeing you again next time. Goodbye.